Hello, those in the room and also those on Facebook and YouTube. We want to welcome you today to our SPED training. This is to make sure we're in compliance with law and also offer the most robust and effective SPED services to our students. And I won't take too much of your time because I'm going to turn it over to Ms. Shannon Barnes from the Disability Rights Louisiana. She's an attorney with that organization, and she's going to be leading the charge today and helping us to make sure we're compliant and, again, offering the most robust programs to our students. So without any further ado, thank you again to those tuning in. This will be available afterwards on video demand, I guess, to principals to do in services and meetings later on. So without any further ado, Ms. Shannon Barnes, thank you so much.
Thank you. Thanks, Grant. Hi, you guys. So this training is following our pre-session where we had a community outreach meeting to get comments and input from the public on what community members would like to see included in the training, and there were some required components of the training. So I had hoped to make this more engaging, but it is the law, and the law often is not that interesting. But I welcome questions, comments as I'm moving through the slides, and then we'll break for lunch, but right before that, I would like to get feedback on where you guys would like to see the second half of the training go. If there are some opportunities for hypotheticals, so some participation, we could do that. There are also additional topics we could cover, so we can just move through the slides, and then once we get to the end of this first section, decide where we want that second half to go. Okay, so I'll just get started. So what today should look like, just starting out with a general overview of the law and rights of students with disabilities in the public school system, and then we'll move into IEPs with a little bit more detail, and then we can go through the IEP document, and I'll just point out important sections, and that way too, if you have any questions as we're moving through the document, because it's kind of a lengthy one, you guys can raise hands there. Then I was thinking we could break for lunch. I'm not sure exactly how long it's going to take us to get through that first chunk, but I don't anticipate it being longer than 2 hours. And so then we'll come back, and I will talk about extended school year services, what the eligibility criteria is there, and then we can either go into other topics or the hypotheticals. Okay, so the legal rights overview. The federal law. So obligations are pulled from 3 sources of law: the Individuals with Disabilities Education Act, or as you guys probably know it, the IDEA. So not all individuals will qualify for special education services under the IDEA. More about that later. Then there's Section 504 of the Rehabilitation Act. This applies to all students with a disability, whether or not that disability is included in the IDEA. So it's more broad than the coverage for the IDEA. Also, there is Title II of the Americans with Disabilities Act, or the ADA, and this is your general civil rights law. So for students who may not be in need of special education, or for modifications to their curriculum, but maybe have a medical need. This would apply, or have accessibility needs. The Americans with Disabilities Act would apply also. Are there any questions about the differences there? This is just a general. Okay. So, can you guys really change outcomes for a student? Yes. With access to the right services, a student's life could change dramatically. It could prevent a student from having to repeat a grade, from dropping out, from being bullied, school arrests for students who are exhibiting behaviors that are related to a disability that could be supported with an accommodation, and lack of access to care. Okay. So who has to follow the federal laws? All public elementary schools, middle schools, junior high, high schools, and including the alternative schools. So, Natchitoches Parish Public Schools included. So what is the difference between the IDEA and 504? The IDEA is, it calls for more individualized education programs. So if you guys have heard of an IEP, that is the product of requirements under the IDEA. More detailed reporting requirements, so there's just a lot more. The law is a lot more detailed on timelines, on what exactly is required, who has to do it, when they have to do it, versus a 504 plan is more general and lists the accommodations and related services, but not necessarily specialized education. And the timelines there are much more relaxed. So Child Find was mentioned in parent feedback. So just a little bit on that. Child Find is the school district's obligation to identify, locate, and evaluate any student that is suspected of having a qualifying disability and in need of special education and/or related services. So the 14 qualifying disabilities that are listed in the IDEA, there are specific, I guess, eligibility or criteria under those disabilities. So a child with autism, for example, may have been diagnosed by a healthcare professional with autism. However, that doesn't necessarily mean that that child will qualify for special education and related services under the IDEA. An evaluation would need to be conducted to determine if that child's autism puts him or her in need of special education and related services in order to make academic progress. So a student with autism may not be in need of special education in order to make academic progress, and in that case would not be eligible for special education, or the diagnosis of autism wouldn't be a qualifying disability. Does that make sense? Okay. So either the parent or the school district may request an evaluation for a student. So why might you request an evaluation? To find out if a student qualifies for modifications and accommodations in school, and to make recommendations about what the student may need and what those accommodations would look like. It must be completed within 60 business days of parental consent. I'll go more into that later on in the details. But just really quickly, I'll note that before an evaluation can be conducted, a parent must sign consenting to the evaluation. And then that timeline starts from the time the parent provides consent. Re-evaluations are required at least every 3 years, unless a parent waives the reevaluation, but may be conducted before that 3-year timeline if a need arises. So if there's something new happening in the classroom with the student that wasn't occurring previously, in the case of new behaviors or issues with grades with other students, just, something else is going on and the accommodations that used to be helping aren't anymore. An evaluation may be needed to figure out what is going on and then how to assist the student in the classroom. Okay, so if the parent doesn't agree with the evaluation, the parent can request an independent evaluation at the school district's expense. 504 evaluation. So this is to determine if a student has a disability that needs accommodations and needs accommodations in school. So even in the case of a 504, an evaluation still needs to be completed before determining eligibility. There's no specific timeline for this evaluation, so that 60-day timeline from consent, that doesn't apply here. You do need to have periodic reevaluations, but again, there's not really a timeline, except in the case of a significant change in placement. So a change in placement may be moving from the regular education classroom to a more restrictive environment. So different school districts call it different things, but to the resource classroom. Is that what you guys call it, the resource classroom? Okay. So that would be a more restrictive setting that may call for a reevaluation before that placement change is made. Okay, so who's heard of response to intervention or RTI? Is anybody? Okay, so so these are changes that are made within the general education classroom prior to an evaluation or during an evaluation for special education to see if the student, if the challenges that the student is experiencing, if those can be overcome with, minor changes like moving the student to the front of the classroom or maybe sitting next to the teacher, or additional time for testing, or just allowing breaks. Just, you know, little changes that could potentially resolve whatever, you know, whatever is going on. But an evaluation for special education cannot be delayed or denied due to RTI implementation. And the reason that's underlined is because in the past, school districts, you know, across the nation have used, and not all school districts, but some school districts have used RTI as a means to delay or deny an evaluation or a request for evaluation, and would sometimes, you know, go through tiers, like, oh, we're in tier 1 of RTI right now. Before we can do an evaluation, we need to move to tier 2, and then a whole school year would go by without the student, you know, getting the accommodations that he or she needed in the classroom. And so that's what the law is trying to prevent from happening. Okay. Free appropriate public education, or FAPE. Under both the IDEA and Section 504, a student with a disability is entitled to FAPE. So a Supreme Court case in 2017 described or helped to us to understand what that means exactly. The program, so the education must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. There's a lot of gray area there. You know, you want the student to be challenged, not too challenging, of course, but enough to where he or she is learning and, you know, is making progress. So, you know, you don't want the same goals in an IEP or in an education program over and over again, or learning objectives that the student is, you know, is already completed, but at the same time, you don't want, you know, something too far out of reach. But it's all based on the individual. And please, if anybody has any questions.
We have one in the chat box.
Oh, okay.
It is, can we go over the RTI requirements more? And maybe some more details on RTI, like what that process looks like for SPLC?
Sure. Let's see. So, in some school districts will do it a little bit differently. I'm not sure, please correct me if I'm wrong. So a parent or a teacher may notice that a student is having an issue in the classroom, and so the parent may communicate a concern to the teacher, or the teacher may notice something going on, and that teacher may go to the principal or to pupil appraisal services, and pupil appraisal services, which is located in the school board, will notify the school building level committee. Okay. And then there is a meeting where the parent is, the parent's invited, but it's just like a general meeting usually. And so during that meeting, the concerns are spoken about, and then it's decided how they'll be addressed, what the change in the classroom might look like if, in the case of seating, preferred seating, or additional time, or breaks, just what the change will look like, and then how long that will be implemented, and what the tracking will look like how will it be documented, and so that'll go into place, that'll be implemented, whatever the change may be, and then at the next, so however long, it could be 9 weeks. After the 9 weeks, the teacher, the parent, the school building level committee will come back together and sit down and look at the data to see, okay, how are these changes helping the student? Did this resolve whatever the issue was? If not, then more intense interventions may be utilized if that seems like it, like it may resolve the issue. At that time, school personnel or parent may call for an evaluation. I mean, really, at any point in time, school personnel and the parent can request an evaluation. And it's a little bit of a gray area exactly when the interventions, when you can say, like, this is not working and no intervention is going to work and special education is needed or an evaluation is needed. But I think in some cases it is more apparent than others, and especially if there is a disability that's been diagnosed, or there's a healthcare professional in the student's life that is also calling for accommodations in the classroom. If there's already existing data that is lending to a need for special education services or for 504 accommodations, at that point, it may be more practical to conduct the evaluation, and simultaneously you can keep the interventions going and pull data from that to consider in the evaluation. I'm not sure, does the district here employ tiered interventions? Do you guys know? Yes. Okay, so they just get more intense with each tier. And again, data is really important so that you can track whether or not these interventions are working, and what else may be helpful and what isn't helpful. I think tracking, I'll stress that throughout, just like recording data, very important. I hope that it semi-answered the question. I do have more slides on right to intervention specifically that if we decide, I can pull those into the second half. But I'm gonna move on for now. Okay, so So what is required? FAPE, free appropriate public education in the least restrictive environment. So FAPE in the LRE. Under the IDEA and Section 504, students have a right to be educated with regular education peers as much as is appropriate for that particular student. The purpose is to discourage unnecessary segregation of students with disabilities. Historically, we've placed students with disabilities in an isolated classroom when those students, studies have shown that students with disabilities benefit from peer interaction and in the regular education environment to the extent that is appropriate for that child, which is a decision that is made by the IEP team. So under the Americans with Disabilities Act, schools must ensure that students with hearing, vision, speech disabilities receive communication that is as effective as communication with others through the provision of auxiliary aids and services. So, so a student that doesn't have a hearing disability, who is able to benefit from I don't know, from movies, from lectures, from class discussion. A student that does have a hearing disability needs to also be able to benefit from whatever instruction is being communicated in through the movie, through the dialogue. So you just need to make sure that if an interpreter is needed, there's an interpreter, or assistive technology, just whatever would put that student on par with his or her peers so that they can benefit in the same way from the instruction. Related services. So under both the IDEA and Section 504, a student should receive all supports and services necessary for that student to receive a free, appropriate public education. And remember, FAPE is whatever reasonable accommodations needed for the student to make meaningful progress in light of that student's situation. So this can include therapies, services such as occupational therapy, physical therapy, speech therapy, behavioral services, including ABA, nursing, etc. Some examples of assistive technology, as simple as calculators, hearing devices, tablets, word processors, text-to-speech devices. There are so many communication devices now. It could even be they have these little tablets with pictures, and a student can point to the picture, be as simple as that. So the IDEA and Section 504 accommodations also apply to extracurricular activities. So that the student can participate in those activities that take place outside of the regular school day, like football games. If a student is in a wheelchair, then the football field needs to be accessible, wheelchair accessible, so that the student can, go and watch the football game. Let's see. I'm just gonna touch on transition right here, but I also have a number of slides on transition services and what those look like that I can include at the end if there's an interest. So let's see. The IDEA requires school districts to assist special education students with transitioning from high school to the post-secondary education world. Transition services are to begin no later than the student's 16th birthday, but they can begin earlier than that. The planning takes place as part of the IEP. So there's a section of the IEP that's dedicated to transition planning. Let's see. And it is a required component of the IEP once that student reaches his or her 16th birthday. The age of majority, remember there was a comment or question about when students reach age 18. So prior to students' 18th birthday, the rights, so decision-making authority is vested in that student's legal guardian. Individuals who are 18 and older can make their own decisions, so we're talking about special education services, consenting to an evaluation, unless a judge says otherwise. So a student may be, with a disability, may be determined to be incompetent or placed under just more restricted decision-making. And in that case, you would have to look to the document, the limited interdiction, or if there is a pre-existing, agreement, look to that document for what decisions that student is able to make. But generally, once a student turns 18, that student does have the right to make his or her own decisions regarding his or her education. Okay, so also, when a student turns 18, the school must give notices to the student and the parent about the rights, the decision-making right, transferring from the legal guardian to the student. So the notice must be provided to both the parent and the student. The parent may tell the school that the student cannot provide informed consent about education. If the student does not dispute it or object, the parent keeps the student's educational rights. But the student has the ultimate right to dispute the school looking to the parent to make any decisions regarding the student's education. So with the consent of the student And if the parent, wants to maintain that control, which is often the case, and this, often the student and the parent are, once the student reaches 18 and prior to that, the student is involved and should be involved, to the greatest extent appropriate in his or her education. But I haven't seen too many cases where a student does not want the parent making decisions about his or her education. So this, I'm not sure if this has come up with you guys, any disputes between parent and student once that student reaches 18? Has anybody experienced that? Yes? Okay, for your son? Okay. And so now is your son making the decisions? Okay. Okay. So there's a collaboration so tutorship is a form of, a means to protect a student's or an individual's interests once that individual reaches the age of 18. That is similar to an interdiction in a few ways, but may be appropriate in some cases to protect that student's interests. Okay. Any questions? Also, I didn't plan for breaks, but it looks like we're moving through the slides really quickly. So if 10-minute breaks, if you guys want to get up and move around, I know this is not, the most interesting. So if your brains start to click off and you just, feel like moving around would help, we can take a 5-10-minute break, get some water, use the restroom. Would anybody want to do that? I want to keep moving. Okay.
So it's 10:39, you want to be back in here? In 10 minutes.
That's fine. We're moving pretty quickly. Oh, yeah, I can tell when it picks it up. Okay, welcome back. More exciting details about the IEP. So now we're going to focus specifically on the IEP and what's required under the IDEA versus the 504 plan. Okay, so after the initial evaluation for special education services, what happens? So first of all, the evaluation is considered complete when the written report, so after the evaluation, there will be a report outlining the assessments that were conducted and the results, or the draft results from the assessments, and the other components included in the evaluation will be documented in a report, and that report will be disseminated by the pupil appraisal staff to the administrator of special education programs, the special education director, or whomever the district has designated as that individual. So at that point in time is when the evaluation is considered done. And that's important because the school district then has a maximum of 30 calendar days to complete the IEP document for an eligible student. So if the evaluation determines that the student is eligible, does qualify for special education and related services, then an IEP team meeting needs to be held and an IEP document needs to be drafted within 30 days. So let's see. So during this 30-day period, 2 activities will take place and be documented. Written notice. So written notice that the school district proposes to provide a free, appropriate public education through the IEP process will be given to the parents. And then an IEP team meeting will take place, and the IEP document will be constructed during that meeting. So written notice to the parents and the completion of the IEP need to take place within 30 days of the evaluation being complete. A little bit more about written notice. What does that look like? So parents must be able to understand the notice. So if it needs to be provided in a different language or interpreted for the parent, it needs to indicate the purpose, time, and location of the IEP team meeting, who will be there. If an IEP team member needs to be excused, it needs to indicate that. The parent's right to take other participants to the meeting. So you need to let the parent know that the parent can bring a physician or counselor to the meeting if they want to. The student's right to participate when appropriate. In some instances, for younger students, and in some instances with older students, it might not be appropriate. The student may not want to. The student, for younger students, he or she may not really understand what's going on. In some cases, it could be very stressful for that student to hear about the different areas that he or she may need assistance, and it just may be harder on some students than on others. It's usually a decision that a parent will make whether or not the student is involved. As I said, the student should be involved in his or her educational program as much as possible, but only where it would be beneficial. Again, it's a student-to-student decision. And the name of the person in the school district that the parents can contact if they have questions or concerns. The notice also needs to explain the procedural safeguards available to the parents. So normally, it is required that parents receive their rights. Usually it's a little packet that parents will receive ahead of the meeting that outlines what their rights look like and what school district's obligations are. The parents need to know that they can negotiate the time and place of the IEPT meeting, and they have a right to full and meaningful participation in that process, in the IEP process. Let's see. And that their consent is required before initial placement will be made. Lastly, that all information about the student will be kept confidential or, within the IEP team. Any questions about that? Because this can really be so dense. Does anybody have any questions? We're going to get a little bit more into the written notice. Okay.
The question says, can you clarify what the state of Louisiana qualifies as in writing or written notice? Would that be a letter, an email, text message, etc.?
So in my experience, written notice is provided from school districts in a form. Usually school districts just have a template, a form that has all of the required information already included there, and with places for additional details that would be specific to the student, where you can put that in, or what's supposed to happen at the meeting. Is this is it an initial IEP team meeting? Is it a review meeting? Just what the purpose of the meeting is. There'll normally be like a little checkbox, and the required information will be included on the form. I haven't seen any written notice that is less formal than that. But please, my contact information is included at the end. If there is a follow-up question about that, I don't mind answering. But in my experience, it's a pretty standard form. Okay, that's a good question. So I would, you want to make sure that the parent does receive the notice, and things can get lost in a student's school bag. So there have been instances too where the parent doesn't use email, and so that makes it a little bit more tricky. a phone call home to notify the parent, like, hey, we're putting this in the mail. Just, be on the lookout. You should be receiving this, and then it could go home in the mail if there have been issues of things getting lost on the way home. But yeah, with older kids, that hasn't come up as much, though it still has come up. But I would caution, side on use caution. You want to make sure that the parent gets that notice, because that's a big requirement. So if a phone call home to alert the parent, say be on the lookout, this is going to be sent home in the student's folder, and then if it's not in the folder, then the parent could call, but that, they have been given that expectation at least ahead of time to check, and that it should be there. An email, if email is a possibility, just because then there's a record that this was sent.
A follow-up question to that is, can this be done through DocuSign?
Oh, for electronic signature. I'm gonna have to make a note of that. I don't, see an issue with that, but I would side on, if the parent can print and sign, that's always, I think, preferred, less questionable, but I'm not really sure about the DocuSign. I think that would be fine. But I can make a note and then follow up after lunch. Any other questions? Okay. Okay, so in the event that a student may be eligible to participate in an alternative or an alternate assessment, the notice should also speak to that. And put parents on notice that that decision will be discussed during the IBT meeting. Okay, let's see. So the parents should also be aware of their right to have the evaluation report explained to them. So normally there is a meeting where the parents and the school district personnel, individuals who conducted the assessments that were used in the evaluation will come together, and there will be a discussion, a review of the components of the evaluation and time for any questions and to go over the results. But if there isn't a meeting, the parent needs to know that that an explanation of those results is an option, is a possibility. And lastly, for parents who disagree with the current evaluation, they need to know or be made aware of the possibility to get an independent evaluation. Any questions about written notice requirements? Do you guys know if Natchitoches Parish uses a form, if there is a form for the written notice? Yes? Okay.
I have a question about the IED and
Mm-hmm.
say for instance, you're in a meeting and the student may be being exited. And there's some dispute that the parent feels like, the evaluation is an error. So that's the point you tell them they have that right, or
I think,
is it a different team of people from the same parish, or is it outside, or how do you do it here? Oh, I'm sorry. In the instance of an exited, special ed student being exited from the program, and the parent disputing that because the evaluation came back and suggested that they no longer needed the program, that's when you tell them there's an the independent evaluation. Is that gonna be done?
that would certainly be an appropriate time to, like, if not prior to that.
So you do bring it up before, I don't know if you, it's
so-
always a sticky situation sometimes.
Sure. It can be during the meeting, it could be prior to the meeting, just so long as there is an awareness, it is communicated, this is an option, because oftentimes parents aren't aware of an IE if they're not told by the school district. So certainly I think that's a great example of a time when it would be important for a parent to be informed about that possibility as an option.
You have to write it down. I have a question about that. The way it reads is that that's automatic, if they just don't agree. Aren't there, like, if that evaluation meets criteria for Bulletin 1508 in the state of Louisiana, based on 1706, then I know they may not agree, but if all of the procedures were followed and that child is no exceptionality, my understanding is that you could go get an independent eval, but if we tell them you can do this is why she's asking, then we would need to pay for that. So are you saying that just if a parent doesn't agree with our evaluation that did follow protocol and criteria as laid out by the State Department of Education, that we have to pay for an independent eval? Our district does?
So there have been instances in my experience where even though the procedures have been followed, there was data that maybe wasn't considered. So a diagnosis or ABA comes in pretty often, just ABA therapy, notes, progress reports that were not incorporated into the evaluation. Usually there's gonna be something missing, or some reason why the parent is questioning the
Normally,
results.
I would think by the time that this would be not very often, because over the course of that evaluation, especially if someone's been receiving services for a while and you can tell that they're not qualifying anymore, because that takes a lot, because you don't have to keep re-qualifying. You see what I'm saying? So, I would think that through parent interview, student interview, teacher interviews, that you would, if the parent were taking them, say, to ABA, and even if they have a diagnosis, say ABA and autism, with 1508, we're not allowed to diagnose. So someone can have a diagnosis, but it doesn't it's not a precursor to qualifications. So, I mean, I would just think that kind of looks like that's the norm, and I would think that would be the exception. That would be pretty exceptional.
An IEE is,
Like we
yeah,
get a lot
it
of
is,
them,
it
and we-
isn't the norm.
We review a lot of them, independent evals, we review a lot of them, they're done, like a children's center or whatever, but then also those evals have to meet the State Department of Education criteria.
They have to be substantially similar, yes,
Right.
yes.
So we have to do components maybe that weren't done, we're kind of required to do a lot more than the independent evals, I guess is what I'm saying, so. So you're saying that if a parent doesn't agree, then they just say, I want one, and the district has to pay for one?
In the event that a parent does not disagree, generally, yes, in my experience, there has been some negotiation with the school district, and whatever the concern of the parent is, maybe then there is an extension to the deadline for the evaluation so that the school district can conduct additional assessments or consider whatever data that was of concern that may not have been included.
And that happens sometimes too, extensions, because it can only be through a parental permission to get extensions.
Right.
Or I was wondering if you were meaning like due process, you know, like if they disagree.
I mean that.
And then when you do due process, then you're also gonna hear, you know,
So
because you would have to have more than just someone saying, well, I don't agree, you know, because then it would have to, you'd have to kind of determine what's missing or what's, I think that's why, is that kind of why you were asking? Because I know you've probably been,
Well, yeah, because some exit evals, you know, are,
it
we
could
know
be
that someone's
touchy,
gonna be very
yeah.
upset with the outcome, but also in a hypothetical situation, a student moved on to another school in the next grade level who had been exited, and there was a request for a reeval because they felt like they still needed accommodation, so that it was a retroactive kind of thing, and they were gonna have to be reevaluated. I would assume that would be like another independent evaluation, so. I was just curious, because, you know, sometimes it gets really tense.
Sure. Whenever there are disagreements, it can get tense pretty quickly. So if a parent is in disagreement and requests the IEE and the school district does not see a reason or disagrees with the parent's request for an IEE, and you're unable to reach a solution, then yes, the next step would be the dispute resolution process. So due process is an available route, and then opportunity for the school district and the parent to work together.
So it's not just automatic in the meeting, because I think there was something there at the beginning that we looked at that had that same comment about the IEE. I was taking some notes, and it led me to believe at that point that was just automatic, that they disagree, school district is obligated to pay for another evaluation. So there still is due process, you're saying, and we tell them in the meeting, in the booklet, and in the IEP meeting, that you understand you have the right to dispute this. I'm sorry.
That they have the right to dispute the evaluation results.
Right, in the meeting, I'm feeding back from somewhere. In an IEP meeting, the parents are told,
before everything is signed off on, that they have the right, they understand that they have the right to disagree, and that, you know, any of their disputations and everything can be appealed to the state, and they understand that. We have to check that off and ask them if they understand that. In the beginning of the presentation here, there was a comment about the IEE, and I just understood it to mean that it was an automatic given, that the parent, how would you say it, the
Retains that
process
right?
goes to the parent, you know, in this particular, I mean, federal law is going to give them that right.
And it is my understanding that that is the case.
Okay.
I will go back and find it in the law, where it speaks to that specifically, and just confirm my
Right,
my
I just don't want to tell a
understanding of it.
parent, you have this right, if they don't understand, you're gonna have to go through this process, though, you know, this is not
Well,
automatic.
So that's up to the school district, really what would happen next. In some instances, the school district has opposed the parents' request to be reimbursed for the IEE, or has declined to consider the IEE. And when the dispute can't be resolved, a parent may, you know, seek resolution through due process, or you know, other means. So that right is an automatic right. My understanding, though, it is not always an easy path to implement to enforce. But I will go back and confirm. Make a note of that. Okay. Any other questions? Okay. That was good, though. That was a discussion. IEP team meetings. Okay. So this meeting, the purpose of this meeting is for there to be communication between the parents and the school to share formal and informal information about the students' needs, educational projections, and services that will be provided to meet the students' needs. The completed IEP is a formal record of the IEP team's decisions. So it'll lay out basically the results, or what the product of the IEP team meeting will be laid out in the IEP document as to what accommodations the student is going to receive, and who will be responsible for implementing those accommodations. So the timeline for completion of the IEP is intended to ensure that there is no undue delay in providing a student with FAPE. So it also helps the school district to ensure that they are meeting their obligations to the student to provide a free, appropriate public education. The IEP form is considered official when the parent and the official designated representative sign the document. This, I believe, is an important statement to highlight, something that needed to be emphasized, I think, in this training, that the importance of the signature of the parent and the designated representative. And we'll go more into who that person is, but those signatures are important because they signify the completion of the document and make it official. Okay. So the IEP team should consider parental correspondence to the school regarding the student's learning environment or placement, any notes from previous parental conferences, and any data gathered during the screening and evaluation period in the development of the IEP, which would include those interventions during RTI. And so I'll stress again, like, data, very important, so that you have information to pull from as far as what was working and what was not working. All right, so implementation of the IEP means that the student begins participating in special education and related services as written in the IEP. A school district shall begin providing services as stated in that IEP as soon as possible, but no later than 10 school days from the time that the parent and the designated official sign the document. And that date of initiation needs to be included on the IEP. So what about students who transfer from one district to another school district? So those students that have been receiving special education from a different school district in Louisiana and then transfer to, let's say, Natchitoches School District, shall be enrolled in the appropriate special education program in Natchitoches with the current IEP or the development of a review IEP within 5 school days of the transfer. So that is to, again, ensure that the student is receiving FAPE and that the school district's meeting its obligations under FAPE. And it recognizes that getting a team meeting together to review the existing IEP and make any changes, may not be able to happen immediately, and so that student's existing IEP from the previous school district should be followed in the meantime. But still, this is a very tight timeline, so something to be aware of. Some additional notes about timelines. Summer vacation. So when an initial evaluation report has been completed within the 30 days prior to the start of summer vacation or during the summer break, the school district may request through written documentation, and really, I think, just put everything in writing. It's just easier for record keeping and for tracking purposes if everything is in writing. So through written documentation, parental approval to delay the initial IEP team meeting until the first week of the next school session is permitted. So just, you need to put it in writing, and the parent needs to consent, and then you can delay the initial IEP team meeting until the start of the next school year. When parents wish to meet during the summer, the school district shall ensure that the appropriate IEP team members are present. And I know that can get kind of tricky too, once school lets out and teachers go on vacation. So that that's something to be aware of as far as planning. just a little review. So, once the student is found eligible for special education and related services under the IDEA, there is an IEP team meeting to create an individualized education program so that the school district can provide FAPE in the least restrictive environment, or LRE. Scheduling the meeting, the notice, so just a review of the written notice to parents needs to include the purpose of the meeting, the time and location, who will be there, and inform the parent that they can bring other participants who have knowledge about the student. School district must attempt to accommodate the parent on scheduling the IEP team meeting, and it needs to be held, or must be held at least once a year, and may be held additionally whenever necessary. Any questions about that? When it would be necessary? Okay. All right. IEP team participants. Okay, so the necessary participants. You have the parent or legal guardian, at least one regular education teacher of the student if the child is or may be in the regular education environment. So in some cases, a student may be in the resource classroom all day, and in that instance, there wouldn't be a regular education teacher in the student's academic program. At least one special education teacher of the student, a school district officer or the officially designated representative. So this person has information and information about the student and ability to make decisions for the district. So the ability to, if a student requires a para-educator, for example, this individual would be able to make that decision to say, okay, the school district will provide the para-educator. An individual who can interpret evaluation results. So that may be the individual who conducted an assessment, but it can also be an officially designated representative in some circumstances. Individuals with knowledge or special expertise regarding the child, including related services personnel, and whenever appropriate, the student with the disability. Okay, so more on the officially designated representative. Okay, so this person is qualified to provide or supervise the provision of specially designed instruction to meet the unique needs of students with exceptionalities. This person is knowledgeable about the general education curriculum and is knowledgeable about the availability of resources of the school district. The district may also designate another member of the IEP team to serve as the agency representative when that person meets the above criteria. Okay. So the school district needs to have on file a policy regarding this officially designated representative and who may qualify. Just as an example, Louisiana's Education Bulletin provides some examples of representatives that may include the director or supervisor of special education, principals, instructional strategists, teachers, or any other school district employee certified to provide or supervise special education services. A member of the student's evaluation team may serve in this capacity. A special education teacher may not serve as the officially designated representative for a student's IEP when that person is also the student's teacher. Any questions about this person? Okay.
The question is, can the ODR ever not be in the IEP meeting?
So, for amendments to the IEP that are not significant, and that wouldn't obligate the school district to hire personnel, that would be significant. It's not a change in placement. There are some exceptions to having, we'll get into that in this next slide a little bit, but generally, no. Generally, there's not really an instance where that person can be excused. I'm trying to think back to my experiences, and even in the amendment, there was one case where that individual was not physically at the meeting, but had already been made aware of the amendment, and this amendment was very unique. So I'm just gonna say, generally, no. So other team members, however, may be excused with consent of the parent and the school district. Let's see, so some examples of when that can happen. So again, the IEP team or the school district and the parent must agree that this team member does not need to participate, and that agreement needs to be made in writing. And that member does not need to be there because the area of the curriculum or related services is not being modified or discussed at the meeting that team member is responsible for. So in cases where the IEP team member, where that person's involvement, or where there would be a discussion about services that would be provided by that team member could still be excused if the parent in writing and the public agency consent to the excusal, and the member submits in writing to the parent and the IEP team input into the development of the IEP prior to the meeting. Does that make sense?
Is there an instance where they can have a substitute from the same related services, say, speak to whatever that absentee, I know with, you know.
So that could be nice to supplement, but that person wouldn't have information experience related to the student specifically. Still, that person, it may be nice to be able to speak to what services could be provided, what those services would look like if we're talking about, speech therapy, so what options may be available to the student. But it's not really, it's not a substitution per se, but could supplement. In that instance, you would still need if you're going to be discussing that area of the curriculum, you would still need the input of that person that works with the student beforehand. Did that answer the question? Sort of. Okay, so the takeaway from the IEP team members. The ODR, that person needs to always be present. There is an exception for other team members in the event that whatever that team member's curriculum or service or area, if that is not going to be discussed during the IEP team meeting, then that person may be excused with the school district and the parent's written consent. If it is an area that is going to be discussed, that member may still be excused if, again, there is written agreement from the school district and the parent, and that team member provides input in writing in advance of the meeting. Okay. The IEP document. Okay, so here is generally what your first page will look like. There was discussion about goals or progress reports, I believe, during the community outreach meeting. So goals should be ambitious but realistic. Again, going back to that need to make meaningful progress in light of the student's abilities. So that would be appropriate to the student. You want to challenge the student, but be realistic. So this page must be completed for all students turning 16 during the IEP year. Oh, I'm sorry, yes, transition services. This may have, okay, so I had the two slides confused. Generally, this is we'll start with this slide. That previous slide was specific to transition services planning, and like we had mentioned previously, that would need to be filled out by the time the student turns 16, but could be filled out prior to that. Planning can begin. So here, the first page. So we need, it requires signatures of all of those attending the meeting. Let's see, the date of the evaluation, and when the triennial evaluation would be, or if there was a waiver, if the parent elected to waive the reevaluation, then the waiver date would need to be included. Here it speaks to communication needs. So for some students, a communication plan is needed, and that needs to be indicated here, and then a communication plan that would need to be included in the IEP. Here, let's see, parent concerns. So this box should be exactly what the parents' concerns are. verbatim. You know, the school district shouldn't interfere or change that content. Let's see. Statewide assessment results for students in 4th grade and older. Those need to appear here. The description of the student's progress. Sorry, I'm thinking that you can see my cursor. You can't see my cursor. So a description of the student's progress, also important. And again, data, so important to track a student's progress. Any health issues need to be indicated. It really walks you through all of the relevant planning pieces for the student that may or may not be a concern. So here, behavior, if there are challenging behaviors or behaviors that need to be addressed, that would be included here. If the student speaks a different language or has any special communication needs, assistive technology also here. And then at the bottom, again, there's a checklist, so you can easily identify the areas of need. Let's see. So I have about 10 more slides here. I know we are nearing an hour again. I'm going to try to get through these as quickly as possible. So if you guys have any questions, just let me know. And if you would prefer me to slow down, we can break and I can pick up where we leave off. If anybody, is there a preference? How are y'all doing? Doing good? Okay. Okay. Okay, so this sheet is for an accommodation. So whether the student needs an accommodation in English, in math, in science, this sheet will list the subject area. It will list what type of accommodation, and then it's important to know what the student's present level is in that subject area. So that can be pulled from past testing, standardized testing, from the evaluation, and then compared to the grade level that the student, to the standard grade level expectation of, you know, whatever grade that student is in. So then let's look at measurable academic or functional goals. So again, the goal needs to be ambitious, but not too challenging. And then the sheet needs to speak to how that goal is going to be tracked. So that might be through testing, through grades. It may be in addition to grades, just how a student performs when given this type of question 5 times. Does the student respond? The student will respond, as appropriate this % of the time. Let's see. It also, so here you will also state who's responsible for implementing this part of the IEP. So if this is for math computations, basic math computations, addition and subtraction, then you might have the special education teacher and there might be a para. Also, the student's going to be involved, and maybe the parent will be involved as well at home. Maybe there are going to be some reinforcers sent home. I could spend a lot of time on the IEP. So please, again, if there are any questions, let me know. Okay, so there will usually be several pages like this in a student's IEP, and each page will speak to the different, like I said, the different subject and goal, and then who's responsible for implementing and what the progress monitoring and tracking will look like. So how will you be able to tell if the student is making progress and is meeting those goals? Okay, so next, the IEP will go through all the accommodations that are standard and available. So the IEP team will look at the evaluation results. There are usually some recommendations in there, and then input from the parent and from the data that was used at in the evaluation, and the other IEP team members who have knowledge about the student will make decisions regarding what accommodations are needed in order for that student to be able to make meaningful progress in his education program. So you will indicate what accommodations will be made available to the student by checking off the boxes. The blank boxes mean that generally the accommodation is not available on that test, so modifications to the LEAP 2025 generally are not available, whereas they would be available in the, just in classroom testing. Okay, so the LAA1 is standardized testing for students with the most significant cognitive needs. Then the LAA2 is being phased out. It was for students 2 to 3 years below grade level. I don't have too much information on that, but if anyone's interested, I can get more information. The Leap Connect is the new name for LAA1. So here you would indicate if any accommodations were going to be utilized for these tests, as well as in the classroom. This slide, dots mean everyone has access to this and that no accommodation is needed. Again, it's just so some instances, school districts will limit the list of accommodations to those that it thinks are appropriate for the student. So we'll, before the meeting takes place, we'll just cut out some of the accommodations. It's best practice to just leave in all the accommodations so that the parent is aware of, so that everyone's aware of what accommodations in total are available. Just moving through. Does anybody have any questions about any of the accommodations? Sure. Assistive technology?
Additional technology, like what we're dealing with now. Basically, since we've moved more into digital literacy and citizenship, are we, providing that opportunity within these accommodations on the form? In other words, if there's a form of technology that could be used to assist that child that's not currently listed.
I'm not sure when the last update was made to the form, but if the IEP team decides that an accommodation is needed and that accommodation is not listed on the form specifically, and it's needed for that child to make meaningful academic progress, then it can, this is not, if it's not here, it doesn't mean it, it can't happen. Right. But I'm not sure the last time that the list was updated. 2 months ago? It's pretty recent. Okay, just moving through the document, more accommodations that are available and where those accommodations would be implemented. Okay. So getting to the end of the document, just some noteworthy things on this page. The regular education classes, so you need to check off when the student would be attending a regular education class, in what instances that would be taking place. And if a student is not in a regular education class, then an explanation should be provided. Similarly, you check off the activities that the student participates in with non-disabled peers, going to the library, lunchtime, snacks, field trips. So whenever the student would be participating with the regular education. So here also, you would check off if the student is participating in an alternative assessment. And or Act 833 if they're eligible for an alternative pathway to graduation, and any special transportation considerations. Lastly, if the student qualifies for ESY services and under what eligibility they are able to qualify. Let's see. And any additional supports needed for the student and related to school personnel. So in the past, I've had a student with dyslexia who needed some additional accommodations related to his disability, and the school district was going to train personnel so as to support the student in challenges related to that student's dyslexia. Okay, 2 more slides. So this page of the IEP speaks to the number of special education minutes. Let's see. I'll just walk through what the slide says. So the minutes that the student is in school per day. So let's see. So the total number of minutes in the student's instructional day will be included, and then that number will be broken down into how many, if the student is in counseling, that would be included here. If the student is in the resource classroom for ELA, that would be included here, and the number of minutes that the student receives counseling and how often, likewise the number of minutes for ELA, and then the total number of special education minutes would be indicated on this page of the form, as well as the start date and then how long it's good for. So usually it's broken down, it could be broken down by semester or school year. Last page. Okay, so here, this is where you'll get the signature of the parent, and there are a number of boxes that you just want to make sure that you read and are checking off as appropriate. So this, let's see, this is a reminder to provide information and notice to the parent for students who are reaching the age of majority. Then parent consent for services or student consent in the case of a student who is 18 or older. And then a checklist to make sure that supporting documentation has been included. So the parent and the officially designated representative will sign, and if we recall that that makes this document official, and then the timeline to implement starts ticking. Any questions? Okay. Any questions about, so that the parents need to sign the first IEP But then, in order for special education services to be provided, but following the initial IEP, the parent's signature, even though it's still needed, that parent can contest what services are included in the IEP, or the decisions of the IEP team, even if their signature appears on the form. So they're not necessarily saying, like, I agree to everything in this IEP document, just that it's complete, that it was completed. Questions? Okay. So when we come back, I'm going to go over extended school year eligibility criteria. Also, there were a lot of comments at the community outreach meeting about qualified personnel and co-teaching, I believe was the term used. So I can touch on that. Let's see, there were some questions about RTI. I could go more into RTI. I could go more into the age of majority, transitions, and transition planning. Let's see. Also, behavior supports and discipline for students in special education. Alternative pathways to promotion. And then some hypotheticals. So that was a number of possible training topics. Do you guys have any feedback, any preferences in addition to ESY criteria for eligibility? What else you would like to see or have interest in learning about? Okay.
Parents are
And
asking
that's-
that one.
Okay, that's brief. So that. Anybody else? Transitions? Anybody interested in transition planning?
Behaviors.
Okay, I think we can break for lunch. Sure. Thanks, you guys.